All right, let's wait a few more minutes for people to jump on.
We can start.
Yeah, I think we can go ahead and start. All right, well, good morning and welcome to this year's final Growth Academy webinar. Today we'll be going through trademarks, how to register the trademark, how to protect it from infringement, as well as how to possibly utilize it so that it is not just sitting passively in your asset accounts. So today, Maria Storey, my colleague, will be presenting and going through these matters, and we'll have a Q&A at the end. Maria, would you like to tell a bit about yourself and your background, and we'll go ahead from there?
Yes. Hello, everyone. I'm Maria Storey, and I've been working in Lexia for 2.5 years, I think. Yeah, and I work mainly with intellectual properties, contracts, registrations, a bit of everything. And I'm the same team as you as well, and we take care of our startup corporations as well. I think I'm just going to go ahead and share my screen and get the ball rolling. You can let me know so when
Perfect.
you can see. Screen. There we go. Is it now like?
Yep, full screen. Excellent.
Yeah, perfect. Okay, so let's go ahead. So I'm going to be talking about trademarks today. Obviously, we have an hour, a bit less, because we want to have some time for questions as well. So it's going to be like, I'm going to go as in depth I can in this time, but please ask questions if something is unclear or something. Okay, so content of today's webinar is we're just going to go ahead with what is a trademark, what can you register, what is impossible to register, and kind of scope of that registered trademark. So, for example, if you register a trademark, it's not going to be projected in all of the goods and services in the world. You have to kind of scope it down, but I'm going to talk more about that. And then just where, kind of like a trademark registration strategy. So where to register and when, and what is the best kind of way to go about and do it. And then a bit about infringements and a few kind of like case examples, and then it's a bit of licensing in the end. Okay, so what is a trademark? Nowadays, it's basically like a distinctive symbol or commercial logo. So it's something you distinguish your products and kind of goods and services from other similar ones in the market. So it can be kind of it can be your company name, for example, and that just kind of covers everything you do, or it can be just one product line, for example. It's just something you distinguish that kind of your main selling points. And also it creates exclusive right for its proprietor. So when you have trademark registration, you have the right to use it in the market in those goods and services that you have been applied it for, but you can also prohibit others using similar logos or symbols with similar products. So for example, I'm just going to say a quick example. You can have two exactly the same trademarks if they protect different goods and services, but if there's even a chance of clashing, so for example, if there's two similar logos that a consumer would get confused that is actually these two goods and services like connected somehow, then that could be a confusion, and that is one kind of main rule of like preventing registerability, or if you have been registering it, it might cause some like infringement claims a bit later. So yeah, that's just kind of the background for it. And trademark can be word, name, pattern, or even a color, logo, sound. Nowadays it can be pretty much anything, but the most common ones are kind of like a word mark, so just a word, or a combination of word and a figurative mark. So for example, a logo that has something like kind of graphical and then a word in it as well. So those are kind of the most popular ones. Okay, and this is about the scope of a registered trademark. So I kind of mentioned about this in the beginning already. So you can't have like one trademark that just covers all goods and services in the world, in every single country in the world, because there are so many trademarks. Nowadays, trademark offices around the world are more strict and more strict, I think, by the month or by the year. So, for example, in the United States, the trademark office is even more strict than in the European Union, EU IPO. Basically, the United States Trademark Office wants you to list the goods and services in a very, very specific way. So that's something that if you go and apply a trademark in the United States, the Trademark Office, I would say every single time gives you like a provisional refusal, where they ask you to refine the goods and services even further. But usually when you do that, it passes okay, and then it's not a problem, but it might be a bit like surprising, like when you get the provisional refusal that, okay, what is wrong here? But it's usually just refining the goods and services even more specifically. So yeah, the scope of protection of a trademark is limited by time, territory, and subject matter. So you can apply, usually that's like that kind of common rule that country by country, except if you have trademark in the EU, there's the EU trademark that covers every single country in the EU, and obviously UK would not be included after New Year's. And then there's also kind of like a kind of similar communal trademark registration ability in Africa. There is certain countries in Africa that have been joined in this one common system that you can apply like in one application, and the application covers many countries. And yes, and then yeah, you have to pick your classes. So that means the goods and services. So all the goods and services are divided to different classes. And nowadays, like I mentioned, you have to be quite specific what you choose. So before, even in Finland, some years ago, like a few years ago, you could choose quite vague kind of headings that basically you would cover all your like goods and services with like just one heading. But nowadays you have to pick every single good separately, and there are different tools to use when you kind of create your goods and services list, the classification. But yeah, if you have any questions, it's good to always ask an IP expert or a friend who's done it before, maybe, I don't know. But yeah, it's the kind of like forming the list of the classes is the most important thing of the trademark application. So that is something you should definitely pay attention to. What we usually do, we kind of create kind of suggestion of classes, and then our client usually fills it up, and we bounce a few messages saying like, okay, what is missing, or what should be taken out of the list. And it's usually yeah, it should be done properly, because it's very important. Because if you, for example, apply for your trademark in goods and services you don't use it in the first 5 years. You could lose the trademark in those goods and services. So you should always kind of keep in mind that cover all the goods and services that are important to you at the moment and in the near future. So if there's something you are kind of, you're gonna expand your business in the next 1-2 years, that's good to also cover in your trademark application, because you can't extend your application later. So if you wanna include more goods and services, you have to apply a new trademark. And the old one obviously would stay valid, but you just have to make a completely new trademark application. So yeah, just cover what is important to you at the moment, and then in the near future, and anything else, like if you have like, okay, maybe in 10 years time we'll do this, or maybe in 5 years time we'll do this, is usually best to leave later on when you know what you're doing and where you're taking your business into. Yes, and yeah, trademark is valid for 10 years in Finland and elsewhere as well, and you can renew it as many times as you want. Different trademark offices have a bit different rules on, for example, in the United States, the trademark office will ask you to show proof that you've been actually using the trademark after 5 years. So in the middle of the 10-year kind of period. And if you have proof, then yeah, everything is fine. And if you don't have proof, then they might cut the classification down. So whatever is in the records is actual valid, and you use the trademark in those goods and services. EU doesn't have this kind of like, they don't ask proof for using it, but other companies, other proprietors can make claims and claim that you are not actually using the trademark in these goods and services. And if the EU IPO kind of considers that that is actually correct, then you might lose it as well. But that's just based on claims. But they do happen, those claims. Okay, so registerability. Trademark must be distinctive and is evaluated in relation to the goods and services for which the mark is sought. So basically, the kind of main rules as well, you have to pick a trademark that doesn't describe the goods and services you are applying it for, and also like it has to be kind of new from other trademarks as well. So if there are trademarks, that kind of comes to the second point, trademark must not create risk of confusion. So basically your trademark cannot be similar than other ones that have been already registered in those goods and services. So it has to be like kind of pop out whatever you're trying to cover it with, and is evaluated as a whole. So that kind of overall impression of it, if there's some elements that are similar than others, but the overall impression is different, then it's usually okay. But yeah, it's that's kind of the main point that all the trademark offices, when they receive your trademark application, they consider is it distinctive, is it that comes to the last point as well, is it contrary to law, public order, or good manners, is it misleading, or for example, there are some countries and some locations that you're not allowed to refer if your products or services don't come from that area. So that comes for the last point, so the geographical origin. So it can't be misleading either. And it depends on the office how the trademark application is being kind of examined. So that comes next. Oh yeah, there's more barriers that comes with what could be barriers when you are trying to apply for a trademark. So there's just a bit of a list. So you can have a look there. Yeah, it can't be confused with others or famous people's names, for example. Good example about that, that we are in the process of applying trademarks all over the world, and sometimes different trademark offices ask proof that if we are applying trademark like name, that the person or the company applying for the name is actually in relation to the actual person, like the name behind the person. So yeah, sometimes we have to go about and get some proof from the magistrates or the church, so you can prove that you basically are allowed to apply for trademark for that name. So that allows you to apply. So yes, let's go to the next one. Okay, so this is the trademark application process in Finland. So PRH, it's the kind of trademark office of Finland. So basically, the trademark office in Finland, they examine the trademark applications throughoutly. So basically, they check for the confusing trademarks in Finland and in the European Union, because the communal European Union trademark that I mentioned before covers all the countries. So for example, if there's French company applied for a trademark there, it covers Finland as well. So that's why the Finnish Trademark Office has to also check all the European Union trademarks. And if there are no barriers found, so the trademark is distinctive, doesn't have other countries' flag, or is not misleading, and doesn't have any kind of confusing like previous trademarks, then the trademark will be accepted and it be registered and announced in the trademark journal that's been published twice a month. And after it's been published, there's going to be a 2 months opposition period where anyone can raise a claim that, for example, there is a trademark that is confusing with this one and the PRH hasn't noticed it, and that's why this trademark registration should be cancelled, or another reason. Usually the main reason for claims is that another proprietor thinks that this trademark is too confusing, too similar with his or hers. So that's the main reason to raise a claim. And yeah, as soon as it's registered, if there's no claims, no problems, it's considered to be active and valid from the date of the application. So not from the registration, but the date of the application. So any latter applications would basically be annulled if they are similar, for example, than your trademark. So you get kind of you're protected from the date of the application. And there's just a quick example of pricing. So trademark application in one classification, one category, one class of goods or services is 225. That's the official costs. And then there's obviously, if you use IP experts, their costs are on top. But this is kind of example of the official costs. And now for the trademark application process in the European Union. So the EU-wide registration is sought from the EU IPO, like I mentioned before, excluding UK from the new years. And the trademark registration process consists of 3 main parts. So that's examining the application, opposition proceedings, and the registration. So it sounds very similar than the Finnish way, but there are a few differences. So the EU IPO only examines kind of the basic requirements of the application. So again, it must be distinctive and can't be confusing and misleading. but they do not check like other proprietors' trademarks. So any previous trademarks in the European Union or elsewhere, like national ones, for example, if there's a trademark that someone has applied in Finland, in the Finnish Trademark Office, they don't check any of that. So sometimes it can be used as a strategy. So for example, if you're using IP experts, they can check also previous trademarks. And if they see that, okay, there's actually very, very similar one. Let's say you're a company working in Finland and you're interested in applying a Finnish trademark. And your IP expert sees that, okay, there's a very similar trademark in Finland, but it's not really confusing, but you can kind of distinguish that this might be something that the Finnish Trademark Office will point out and will not allow the registration to go through. This is one way to kind of go around, if you will. So you can apply for trademark in the European Union, and you know the European Union, the Intellectual Property Office, will not check the trademarks in like beforehand. So the system basically relies on the claims again. So the EUIPO only checks the basic requirements, and then it's been the trademark will be published, not registered like in Finland, but published, and then third parties can raise claims. And of course, for parties to be able to raise claims, they have to be consistently monitoring what's happening to EUIPO, what trademarks are being published, and then basically have an active enforcement strategy to be able to, react quick enough and raise that claim. And if there's a chance you can take that, for example, that Finnish similar logo owner doesn't raise a claim in the EUIPO, and if he or she doesn't, then your mark will get accepted, and then it's been registered. And once the kind of opposition period is done, it's been registered. So then it's done and dusted, not like in Finland where it's been registered and then there's an opposition period. Yeah. So that is something you can use as a strategy as well, if you know that there might be a confusion mark, but it's not really a problem because the other company does something different or has a different clientele or whatever the reason is. Same thing here is valid for 10 years from the date of the application in all the EU countries. And there's an example of pricing. So this is 2 categories now. If I remember right, the one category to one classification of goods and services is 850 and 2 is 900. And I think the next one is 1050. So yeah, it's more expensive than the Finnish one, but then again, you get all the countries in the EU. Okay, and then we're going to go for the worldwide registrations. So again, this doesn't mean that there's one application for every single country in the world, but there are multiple countries that have joined the Madrid Protocol, so where you can use one single application and you can pick multiple countries where you want that application to go through. So what happens is you have a basic registration first. So this is not the first one you can do. You have to have either national registration like in Finland or communal like registration in EU. And when you have that one, then you can apply the trademark elsewhere through WIPO, so the World Intellectual Property Organization. So they will take your application, they check for formalities, again, for the basic requirements. And then when it's been accepted there, they will send it in all the countries you've listed in your application. And then there's going to be the next steps in those countries. So for example, the Finnish Trademark Office will check those applications being designated here. And if you applied for trademark in the US, same thing there, the Trademark Office there will check again, according to their requirements, and the same thing, they will give provisional refusals if the classification is too wide or unspecific, and yeah, and then also you can, for example, I mentioned the African or it's called OAPI, the kind of one single trademark for many countries. That's also part of the WIPO. So you can apply for one single application to all of those countries there. And also EU is also part of the Madrid protocol. So you can also apply a trademark. Once you've been applying it in Finland, you can choose, for example, EU, States, China, for example, and then, yeah. And I'm just going to jump on the last point. So the application fees, they vary a lot depending on the country. If you are applying for just China or just the US, I usually check the prices of the local lawyers for our clients as well, just to compare, because sometimes the difference is not a lot, and also the trademark application will proceed a bit more smoothly when you apply straight in the trademark office with the help of local lawyers, because it doesn't go to the WIPO's main office for that formalities check. So yeah, usually it's good to compare a bit on the prices, but I've seen that if you apply for multiple countries, let's say Australia, United States, Canada, and China, then usually the WIPO is more cost effective when you have many countries in there. But both ways are possible. So you can use the Madrid protocol for many countries. It's quite can be cost effective, and it's quite kind of like straightforward. And or you can use local lawyers to apply directly in those countries' trademark offices. And you also have to remember that not every country is part of the Madrid protocol. So in some cases, the only way to have a trademark registration in a certain country is to go through the local lawyers and apply straight there. And yes, again, open, valid for 10 years. And is there anything else I want to mention? No, that's it. Yeah. So basically, it's this is one good way to get your trademark registration in multiple countries, but there's also another alternative, which is the local lawyers, but that's very case-by-case basis, and also the prices vary and such. Okay, let's go next for the trademark infringement. So once you have your trademark application approved and you have a registered trademark, now it's important to basically protect it as well. And so it doesn't just sit there. You have to be able to enforce your registration, because that increases the value of your trademark and your brand, that you actually take care of it and your IP kind of portfolio. And one good way to kind of go about with enforcement is to have like IPR strategy or like an enforcement plan. So for example, there are cases that you might want to like just decide beforehand that if this happens, we'll take these measures, and then that's it. We're not going to go to court proceedings or any of that. So kind of like have a plan ready. So whenever there's infringements, it's always advisable to act quite quickly. So when you have a plan ready, at least like a draft of a plan, then you know, okay, if this happens, this is our options, this is how much they usually cost, we'll go about and do this or something else. So basically when the infringement happens, you don't have to start from the beginning saying, okay, what can we do? Who can help us? So I definitely recommend a strategy or plan, enforcement plan. So enforcement actions can be divided into initial measures, which is usually cease and desist letter, online enforcement, civil enforcement, criminal enforcement, and customs enforcement. And in order to establish what enforcement mechanism is most effective in what case, you must consider the following. So basically, if you notice that some other proprietor, some third party is using same or very similar trademark for his and her goods and services, then you have registered a trademark. Then you have to consider that, okay, where this infringement is happening, is it a jurisdiction where you have a valid trademark registration, and also the goods and services the other proprietor or third party is using the trademark in, are they the same or similar what you've covered in your registration? So that again comes to the list of goods and services. So if you check like, okay, it is a jurisdiction that way you have a trademark registration and the logo is confusing, the goods and services are similar, and there's a genuine risk that the public, the consumers are confused, that they think that this third party is actually selling your products or services, then yeah, go for the next one. So is your intellectual property applicable for this infringement? For example, if you registered a trademark, but then the other person is using, for example, your design, it might be a bit more trickier if you haven't registered your design right. So you have to kind of go to the nitty-gritty and see what actually is being here, what is the infringement actually about. And if you consider that actually, yes, there's is for example, a trademark, is a logo and you've registered it, go ahead. Then that last point. And this is similar, what is the infringement in question? So is this something happening online, or is this something that you know that there are actually like consumer goods that are being, for example, brought to the country that are fake, for example, counterfeit goods. So what can you do in that specific case? And there's just a little example, just like an infringement in Finland. So, for example, a third party begins to use a very similar logo compared to your registered trademark as a symbol of its own products. First case is usually to send a cease and desist letter. So I believe it has a bit more effect if it's done through attorney's office. It has a bit more maybe power to it, because then, you know, the other party knows that you're willing to take the steps, you're willing to maybe go ahead with civil proceedings. So yeah, consider that when you face this kind of infringement. And basically in the letter you state that this is a registered trademark, you've infringed the exclusive rights of the proprietor of this trademark in these and these ways, need to stop, or then would, for example, start court proceedings. And then you have to consider, if the letter has no effect, you can send maybe another one reminder, and then consider whether you want to take it to the market court, or if it doesn't have if the infringement is not massive, you might want to leave it as that. But it's always kind of depending on the size of your company and how far you're willing to take it, how important the brand or the trademark, that line of goods and services is to you, and also consider the harm that could come from the infringement. For example, if the counterfeit goods or the services are kind of diminishing and diluting your brand value, then it's good to consider take further steps with that, just to protect your brand, protect your trademark, and so on. There's another example of kind of online infringements, so abroad, trademark infringements abroad. So one example, products bearing a similar or same name as your registered trademark appear on Amazon or Alibaba or any of these platforms, but the products are not genuine. Then the first thing I would say is to ensure that you have all enrolled, or if you haven't yet, then do it. Basically register your rights as a proprietor to the Amazon brand registry, or Alibaba has own IP brand protection system, and they are active once you kind of state your rights and you have the proof for your registration certificates, for example, to take down any products that are infringing your rights. So that is probably the best way. You can also, send a cease and desist letter by, if your main desire is to take those goods down. This is the best way, I would say, to go about and do it. So as you see, it depends on where the infringement is happening. Is it online? Is it customs? I know the Finnish customs have a similar IP protection system where you can register your rights, and the customs will kind of keep those rights in mind and follow the goods are coming to the country. So yeah, you have to kind of consider different infringements, what you're willing to do with it, what is the best way to go about and enforce your rights. And yeah, plan is good to have, so you know exactly what to do and when. And then there's a few more just a case examples, just the general case examples, real life examples. So for example, there's a case where there's two companies carrying the same name. One has registered trademark for that name, and one has registered trade name. One party has registered trademark and registered trade name, and the other party has none of that, but has kind of extensive use of the secondary mark, which is the same name of the company. And after few cease and desist letters, nothing really, they were not effective, so the case is now in process in the market court. So the two parties didn't come to conclusion or agreement on how to solve these problems. Two companies carrying the same name, and the name is associated with similar or same goods and services. So there's a real chance of confusion, and the confusion is already shown through different means. So that is just one case that could happen, that there's another party that appears on the market or been there for a while, and you just kind of find it later on and use the same mark. So what's happening there? You might wonder why this is even going to market court if one has registered trademark and registered trade name and the other one doesn't. But there is also a way of securing your trademark, which is through extensive use. But that is a very difficult way to go about and have a protected trademark, if you will, because it requires years of extensive use, and you have to show that your clients and other, for example, manufacturers or other parties that associated to your company, also when they hear that name or that secondary mark, they see that logo or whatever, they immediately associate that with your company. So it's a very difficult thing to show, but it's possible. So that's why they were in disagreement, and that's why the market court can now say its piece on this. And the next one, two companies again carry very similar trade names and very similar logos. One is registered trademark, both have registered trade names. So we have one registered trademark, one party has, and again, registered trade name, and the other party has just a registered trade name, but hasn't registered that logo. And this is still under negotiation. And the parties are trying to find solution to coexist in the market and ways to kind of like avoid any confusion amongst the consumers. So yeah, it's also possible if both parties are willing just to coexist as well, as long as the consumers are not confused, because no party wants that. Last one, two companies with similar trademarks for their products. So there's only one letter difference between the marks, and the goods and services are almost identical. the Finnish Patent and Registration Office, so the PRH, stated that there are no risk of confusion amongst the consumers. So basically, there was already in the market one trademark. Another party was not aware of this one, applied for a trademark, and it passed the Finnish Trademark Office's examination, was registered, and then there was a 2 months of opposition period I mentioned before. And in that time, this earlier trademark, the proprietor of the earlier trademark registration raised a claim and claimed there was confusion. Trademark Office considered that claim, decided that there was no confusion, but the other party was not happy with this. So the case is now in the market court, and the other party is asking it to be returned back to the Trademark Office for more consideration, and that's still in process. So yeah, those kind of real life examples are possible. So it's always advisable for startups and any company kind of consider your IP portfolio very in the beginning of the company's life, if you want to say, because they definitely, even though it's like a rather big monetary kind of expense to register your trademarks or design rights or trade names or whatever, but it definitely saves you more trouble later on, because it can also be happening, for example, in these cases when we know the final result. It could be that the one party, for example, loses its trade name or trademark or whatever. That means you have to change completely your brand, you have to change your trademark, and that is way more costly, because then you have to kind of re-establish yourself amongst the consumers, and it can be very, very time consuming and money consuming as well. So it's good to have those kind of intellectual property rights in place in the very, very early in the company's life, and also to have that enforcement plan that I mentioned. And then my last point, it's good to also consider not just to, like you mentioned in the beginning, just to have your trademarks and IP portfolio just to sit there, but it can also make money for you. So trademark registrations, for example, are not just to covering your bases. They're basically allowing you to like work and sell your goods and services in those areas that you've protected with the trademark. So you're covered, and also you can also prohibit others to dilute or diminish the value of your brand by counterfeit goods also. And also it's good for investors that they also look always that your IP portfolio is on point. And lastly, you can make the trademarks or other IP rights to make money. So licensing. So in many ways, it's very good to have your IP portfolio done very early on. So I'm going to quickly run this through, and then you can fill if there's anything I missed. So when is a good idea to consider licensing your trademark? Basically, as soon as you have a valuable brand and a potential licensee, so go ahead and do it. And how do you go about and license your trademark? So when you have your potential licensee, next step would be to draft a license agreement where you both agree on your rights, obligations regarding the licensed IP trademark. And then the next 3 points are like important when you negotiate your license agreement. So what are the important things to write down in the draft agreement, and like how specifically they should be, and so on. So some of the problems you might want to consider that might come about. So you want to avoid these with your good license agreement. It's important to define the scope in which the licensee can use your trademark. And also, like, you have to make sure that the licensee doesn't diminish or dilute your brand value with activities. So it should be made clear on what purposes the trademark may be used for in connection to certain products or services only, and also are there any territorial limits or other limits that you wanna define that licensee right, basically. And it's also important to define how the fees should be paid and what basis can the licensor, so you, can raise the fees. Is it a fee per month, or maybe a one fixed fee per year, or is it some revenue share? So, for example, a licensee who wants to sell some tickets with connected with your trademark, is it like you take a percentage of that ticket price, or how you want to go about and do it? And it should also be established that the licensee has no right to make changes to the licensed trademark, and the licensee has no intellectual property rights to the trademark besides the right to use the trademark according to the license agreement. So the licensee can't make changes, and even if he or she would make changes, you own the rights and so on. So it's only the right to use it according to the agreement. So that would be all from me. Is there anything you usually want to add to this licensing or anything else?
Sure. So with licensing, what I would recommend to think about is once you actually do have something worth licensing. So essentially, you trademark to protect your brand, protect your product, protect your service. But once that has been built up, you want to think about whether you can spread out the streams of revenue coming into the company. And licensing, once you do have a recognizable trademark, is a good way of taking that trademark, the passive protection of the trademark, and making it active and creating a revenue stream. So like Maria said, whether it's from providing the license for another party to create, let's say, a product under the same trademark, and in that way have a revenue share or a fee per month for using the trademark, or whether it's using the trademark as in connection with another service or product to create more value for that service or product, and in that sense having a way of creating money or revenue stream for your company through the utilization of your trademark. This is, for example, with any content related industry, is a very normal way of going about it. So once let's say a game has a trademark that is recognizable, a lot of companies have started to utilize the trademark to create, let's say, plush toys from the game, or amusement park activities. So there are various ways of utilizing your trademark to create a new revenue stream, which can be even more beneficial than the first revenue stream that has been created and which you have protected with the trademark. So it is something that can become a very central to your business model over time. So that's why it is clearly important to protect the trademark early, so that once you've actually built the brand, build the asset to the trademark, and it has become something that can be utilized, you'll be prepared to utilize it, and you've already protected it so that nobody else can start utilizing your trademark in the future. So I think that's just a general point on turning your trademark from passive to active and creating revenue for you. But going on from there, we've come to the end of the presentation for Maria. So thank you, Maria, for that. There was already one question from Kelly, which was, what is considered valid proof? I think this was referring to the trademark in the US for use of the trademark. Also, if you have any questions, just put them in the chat and we'll go through them now.
So valid use of the trademark in the US, probably connection with the 5-year mark I mentioned that they ask for proof. Usually kind of good proof would be if you have any paid advertisements in US where you can see your logo. news articles, any proof that you've been in fairs, or if there's any invoices that are directed to US clients, US addresses, US companies, in connection with the goods and services that you are protected with your trademark. So if there's any, like, let's say your trademark covers some clothing, for example, and you have an invoice showing that like some pieces of trousers and tops, and they cover your trademark, and that's in the invoice directed to US company, that would be a good proof as well. So stuff like that. It can be a bit of everything, or just a few from the list I just mentioned. So it can be a very variable list of things that you can prove your trademark use. Hopefully this answered your question.
Excellent. Then we have a second question now, which is from Jaakko, which was, what is the best and most cost-effective way to monitor new trademark publications for potential infringements internationally?
I would say, I think, obviously depending on the size of your company or how much you're willing to kind of put towards this, again, this comes like how important your brand is to you, how kind of, if your company is very strongly kind of based on or focused on consumer goods, so you have a big crowd, for example, online, that means that your brand is very important to you, because your consumers and your customers will know your brand. Then you might want to put a bit more money towards this. And I would say this is probably the best way to contact an IP expert, because they have trademark watch tools. So whenever there is a trademark anywhere in the world that's being applied that's very similar to yours, you can get notification where your IP expert is explaining, okay, there's a trademark application in, let's say, China, it's very similar. Do you want to go about and do something about it? Or, so I think that's probably the best way, because then you don't have to monitor different trademark offices' websites, and also most of the kind of tools IP experts use for these like watch tools, they are quite expensive. But obviously, when we have a lot of clients, it's okay. But with you, if you have, like, let's say 2 trademarks, 1 design right or so, it's more cost effective to use the services of an IP expert than acquire those tools by yourself, if that makes sense. Yeah.
Yeah. We don't have any comments currently or questions currently in the chat, but as a general comment, with regards to IPR strategies, having a strategy, a business strategy in general, you should also have a strategy for your intellectual property rights, to understand how you're going to utilize them now and how you're going to utilize them in the future, or protect them now and protect them in the future. It creates actually having value when you have a strategy for it, so that you know what you need to protect now, how you can protect it now, especially at the startup phase, when you might not have enough equity or revenue coming in to protect the rights in general, to know how you can protect it cost effectively in the beginning, so having the proper NDAs in place and so forth, but also then having the strategy ready for when you do go public and when you go international, and which countries you need to register the trademark for, and in what sort of process and stages, whether you apply first in the European Union and then go forth to the US and China, but at the same time, understanding that once you do protect your trademarks, you need to be prepared to protect them and take the claim against infringements. So you need to have that money prepared for that sort of stage. So understanding when that right is. Also, once registering the trademark, it may bring about, let's say, people who try to take use or to utilize it, sort of the situation you're in, depending on the company's size. So trademarks might be registered elsewhere in the world. So there are unfortunately trolls that go through trademark registries and start registering the trademarks in their regions and countries. And in that sense, it might affect your sort of growth into the future, but also understanding that you need to register the trademark once you start going international, start going global, because it might cost you a lot in the future. There are cases globally where large companies, which are recognizable nowadays, have forgotten or not looked into trademarking early enough in certain countries, and are currently or just closing cases where they could have registered for the trademark for hundreds or a few thousands and now are paying hundreds of thousands to be able to get their trademarks back. So this is a part of creating a strategy for it, understanding what trademarks or intellectual property rights you have in general, how to protect them, when to protect them, how to protect them from infringement, how to take a claim forward, when to take a claim forward, as well as how to utilize it once you've actually protected the trademark, and how to bring in, take that passive trademark and passive intellectual property right and create a new revenue stream from it.
Yes, that is very good points. There's a question: what should be taken into account when considering the geographical scope of a trademark that is to be used for a product or services sold globally? This is a good question, and I think it definitely is related to, for example, like games, like Juuso mentioned. They might be sold through different platforms that are available everywhere in the world, and that is like, it would be insane to cover your trademark or your trademark registration in every single country in the world. It would just be so expensive, and to be able to also enforce the rights, it would just be an endless fight. And I think you would have to have people separately just working with your IP portfolio just for that. So I think that's just not even a possibility, and therefore I would recommend to consider what countries are the most important for you. So in what countries you have the most customers in, project those. If there's countries that you know that there's a lot of might be like Juuso was mentioning, like third parties that basically do that for a living, that they register other companies, other proprietors' trademarks, and then want to sell them later on, maybe cover those countries that you know that they might be problematic in the future, if they are important to you. And I think that's probably the best general rule to go about and do it. Where you have the most consumers, where you have the biggest presence, and pick from those countries the most important for you, and then register those ones. It would be impossible to register every single country in the world, especially when not every single country is part of the WIPO, like I mentioned. And in some countries, I know in South America, the trademark registration process might take years, like 5 years.
Yeah, it's a difficult process, but again, it's a part of the strategy on how you're growing your company at the startup stage, when the trademark or brand is not known. Registering it at that point in the regions where you're starting off the company is advisable, and in the regions, once you do have enough revenue, enough money to start registering it elsewhere, then looking at which countries do you want to enter. Although, for example, games and similar services are sort of born global, do remember that once you do go global, it's not just the trademarks, it's not just the IPRs that you need to protect and take into account, but there are various other legal matters that need to be taken into account when spreading globally. And in that sense, it does require a bit more planning than just launching something, putting it out there into the world and seeing how it sticks. Of course, there are of course services and products that go viral, which is always a sort of positive, but it brings around also positive problems, which is what you need to take care of in that sort of exponential growth stage, which requires a bit more planning, a bit more resources, and partnering either with a law firm or bringing someone in-house to assist you with or an IPR expert to assist you with sort of your IPR portfolio and how to protect it.
Well said. I
All
think
right.
time is up.
Yeah, time is coming to a close. Thank you, Maria, for the webinar. Thank you for the really good questions this time around. And yes, as this is the final webinar for this year, I'd like to thank for this year the Growth Academy and all of you who have been joining in on the calls, and as well as in the future, or hopefully you will be joining us next year. We'll be organizing these almost at the same rate. And yeah, I hope you've enjoyed the webinar this time around, and then jump on board next year as well. Maria, any other thoughts?
Happy holidays.
Yep, happy holidays.
Yeah.
Thank you, everyone.
That's all for me. Thank you, everyone. Thank you.